Hello, everyone, and welcome to Family Law Now.
Hello.
How's your day going,
Morning.
Russ?
Great. Exciting topic today.
Yeah, very.
Yeah. Good
Yep,
job with the music as always.
thank you. I decided to mix it up a little bit today, get some more summer feels going.
You're the master of non-copyright background
Thank
material.
you. I try.
Good morning, Megan. Good morning, Paul.
Name.
Good morning.
Good morning, Susanna. It's quite the dream team we've assembled here today.
It is. I'm really looking forward to this discussion.
I think we should be broadcasting from a cottage, like on a dock somewhere.
I like it. I like it.
We could all change, we could all change the background to a cottage.
Now
On
you
a-
make the suggestion, Russ.
On a little inner tube floating down the river somewhere.
Sitting on a boat doing this, that'd be kind of cool.
Yeah.
Did you see that video online with the woman who asked for time off so she could take a vacation? She was told no. So she logged into a Zoom call and she was trying to unmute herself, but instead she did something with her video and they saw her on a boat on the water.
Yeah.
She's like, oh shoot.
Oh my God.
Yeah. Caught.
It's amazing where people can work from these days. Just read an article this morning about a big law firm boasting about renovating their office space and getting people downtown. It's like, I think they're missing the mark. Nobody's coming back. You could change the plants all you want. I think people are kind of comfortable where they are.
Have you been on Bloor Street recently? It's such a ghost town. It's crazy.
I go down to the towers once in a while, and I remember the underground used to be so exciting and fun, and now you're seeing empty shops and nobody shopping. It's really changed.
I have a feeling it'll convert all that commercial space into condos soon enough.
Yeah.
Well,
So-
that's what quite a few of the high-rise office buildings, what they're doing is all the empty spaces. So they're moving all the tenants down to the first like 3 or 4 floors, and then the balance of them they're going to turn into residential condos.
Yeah.
Yeah, they're doing a lot of that in Chicago. They've got some big empty office buildings. But Bloor Street, no foot traffic, Megan?
Not really. Not like it used to be.
Yeah.
Right? Like you walk down and all those big box stores are closed up, a lot of empty space. Definitely wasn't like what it was before COVID.
Well, even to get to the city now, right, is a challenge. You got Queen Street shut down,
Yes.
lots of traffic. I know whenever I see a concert or a hockey game or something or a baseball, it's just chaos.
Yeah, I just take the GO train. It's not worth getting in the car and getting stuck somewhere or having to
Right.
pay for parking.
Yeah.
Yeah, agree with that.
Oh, we just go up to the Key to Bala and grab a cottage on Lake
Oh
Muskoka.
yeah.
Taking a show up there.
Those are always fun.
Yeah. I love seeing all the boats coming in for the show. Some of them don't even go. They just park in the harbor and listen to
Yeah.
them.
Now, I always thought it'd be fun, but I can't recall if they actually have boat taxis or not, if you do rent on the water and then want to go to a show. I can't
Yeah.
remember if that lake has boat taxis.
We were in Honey Harbor and there was a cottagers party end of summer, and some industrious summer students were taking people back and forth from their cottages so they don't have to drink and boat. It was pretty
It's good.
great idea.
Yeah.
Give them $20 or something, right?
Oh, for sure.
We
Well-
rented an island in Honey Harbor last year, actually. We rented an
Oh, yeah?
island, actually off of a lawyer that we did 10 years ago. And we called her up last year and said, you remember us? And she was like, oh yeah, you left the place way nicer than what it was when you got there. So we
Oh,
would love
nice.
to rent to you again. Actually, it's funny. She said, we rented to one other person. We had a bad experience and we stopped doing it. But she goes, for you guys, absolutely.
That's
Yeah.
nice.
So Honey
That's
Harbor
a
is great.
busy boat traffic area, that Honey Harbor, those channels in around Frying Pan Bay. But we top of the hour, Daphne, what do you think? Should we make a start? We've got 274 people registered, already a bunch online. We're live streaming to YouTube, so everybody watching us online on YouTube, thank you for joining us. And what are we talking about today?
Yeah, thank you, Russell, and thank you everyone for joining us today for Family Cottages, Navigating Transfers, Disputes, and Legacy Planning. This session has been accredited for 1 hour of professionalism content with the Law Society of Ontario. And today the panel will discuss the Family Law Act and cottage ownership, acquisition and property classification, tax implication and transfer considerations, valuation complexities and market considerations, emotional and family dynamics, ownership and future use decisions, selling the cottage, timing and process, liability and legal risks, managing ongoing costs and responsibilities, and legacy and estate planning. So
We're gonna
lots
get
to
all
cover
that
off.
done over the lunch hour.
Yeah, lots to cover off today.
Let's find out who our audience is. What do you think?
Yeah, sounds good. I'm going to launch our first poll here. And
So
as
everybody,
always,
please participate. Let us know who you are, and then we'll look at the poll results in a moment.
yeah, and as always, we encourage you to participate in these polls and to use the Q&A feature as well throughout the event. Our panelists will do their best to answer questions. And all the resources mentioned today will be included in the show notes, which you will receive via email later this week if you've registered for the event. So I will now introduce the panelists. First, we have the host, Russell Alexander. He is the founder of Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve clients in all aspects of family law. Russell has written 4 books on separation and divorce and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology, and the law, and cottages. Thanks for joining us, Russell. We are also joined by Susanna. Susanna Critchlow is an associate lawyer who is fully trained in collaborative practice. She has over 12 years of family law experience and works hard to achieve favorable outcomes for her clients in family law cases. Susanna approaches client consultations with a compassionate but analytical mindset and endeavors to provide her clients with the very best representation possible. She is also passionate about supporting local and international charities and humanitarian aid organizations, including World Vision International, ERDO, and the Salvation Army. Thank you for joining us, Susanna. We are also joined by Megan Beck. Megan, happy to have you. She is a lawyer at Titlers PC in Port Perry. She has worked alongside George Smith, the senior lawyer at the firm since 2014. Over her 10 years at Titlers PC, Megan has developed expertise in a range of residential real estate transactions. She has also gained experience in complex real estate matters, such as commercial real estate, rural and recreational real estate, development, title issues, and more. In her personal life, Megan loves to read, exercise, travel, and volunteer for dog rescue organizations. Thank you for being with us today, Megan.
Thank you, Daphne.
And last but certainly not least, we have Paul Raymond. Recruited into the real estate industry in 1989, Paul quickly adapted his tremendous competitiveness and success as a multi-sport professional athlete to the real estate arena. Paul's accolades include the 100% Club, Platinum Club, Exclusive Diamond Club, the prestigious Lifetime Achievement Award, and in 1998 was inducted into the RE/MAX Hall of Fame. Paul has been the #1 agent at his brokerage numerous times, including in 2002 and 2024 at RE/MAX Jazz. Actively involved in his community, being involved in many charities, including Sick Kids Hospital, Lake Ridge Health, and Their Opportunity. 95% of Paul's production is from referrals and repeat business from his past clients. And I will now hand things over to Russell Alexander to discuss poll results and get started with the presentation.
Thank you for those kind words, Daphne. Fantastic as always. Let's run let's see our first poll results. And we've got 33% lawyer, family lawyer, 52% lawyer practicing in another area, financial professional, real estate professional, and law clerk. One more quick poll before we make a start. Can a cottage be a matrimonial home? So you're going to get a number of options here. What is a matrimonial home? What is a cottage? And some others. So, but what is the cottage one is kind of fun, because when we were preparing for today's presentation, I remembered a case where an RV had the tires removed and was situated on a lot on some building blocks. And the question for the law students was, is that a cottage or is that an RV? I think Megan had the same professor, right, Megan?
I did. I remember that case. I think there's a couple cases on that, I believe. And one case went the way of saying, no, it's just a chattel, it's a movable piece of property. But once they affixed it to cinder blocks, they said it's a fixture and should be considered a dwelling, which then could be a cottage.
Well, think of these big RVs, right? They're hooked up to septic systems and water and power and everything. So yeah, it's an interesting question. And we were even Paul and I were talking about tiny homes. Some of these tiny homes go for $200,000-$300,000. They're on wheels, but not for long once they get to their final location. So could be an interesting fact.
I think it also depends how long it's been there. And that was one of the driving factors in the case, right? It's not 2 years. It's been sitting there for 30 years. That's definitely going to be a factor.
You got the vines growing up on the side.
Exactly. That's what I'm picturing. Trees growing out of it almost.
All right. Let's see what our audience thinks on this question. Yes, 66%. It depends. A lot of lawyers in this crowd. That sounds like a lawyer answer. It depends at 28%. So let's get into this. Family Law Act and cottage ownership. Let's start with Susanna, and then maybe we'll get your input too in a moment, Megan.
Thanks, Russ. So family cottages are considered a matrimonial property if it was acquired during the marriage. And under the Ontario Family Law Act, that makes a cottage subject to equalization. And so you might ask, well, what is equalization? And equalization is the division of assets and debts upon a marriage breakdown, the assets that were accumulated during the marriage. So we have to consider, when was this cottage acquired? Was it acquired pre-marriage? Was it acquired after the date of marriage? Because that helps us determine what value is going to be equalized for this particular cottage. So if we're talking about an asset that was acquired pre-marriage, we look at the appreciation and the value. But if we're talking about a cottage acquired during the marriage, we're looking at the full value for the purposes of equalization. When we're looking at equalization as well, ownership is also really important. How is title held? How is it not held? We have to look at trust cases, for example. There are many couples who are separating and who come to us and say, well, you know, I put some money towards that acquisition, but I'm not actually on title. But what am I entitled to here? Am I entitled to part of that cottage? And we have these questions coming at us all the time. And so lawyers tend to encourage clients when dealing with these sort of properties that, it's always wise to get proper family law advice and not just go to a real estate lawyer and, put title in one name or another name. But sometimes people fail to consider that family law advice from a family law lawyer is also important, because while we may not think that a relationship might break down when you're in a honeymoon phase, when everything is going well, these things inevitably happen. And so if proper mechanisms are not put in place to determine how that cottage is going to be shared in the event that a marriage breaks down, that can create significant legal issues, significant financial burdens for the parties moving forward. And Megan, I'm sure you've had to deal with this a lot in your practice as well.
Yes, for sure. And I think something too you're getting at, Susanna, is that we have different types of ownership that you're encountering too. So sometimes it is one spouse is just the sole owner, and that might actually be a little bit more cut and dry. But once we have the family cottage, we're talking about some ownerships that could be held in joint tenants with mom and dad. And so in that way, as a joint tenancy, there's going to be that right of survivorship. So if that parent passes, then the surviving owners get their interest. Or we're dealing with tenants in common. So that is dividing the interest in the property. So that way, if say mom or dad passes away, it's falling to their estate. And how you deal with the cottage will be dealt through their will. So those factors, I can imagine, also weigh into the interest that you're dealing with on the family law side and determining the value.
And we've got, there's lots of case law too, right? What I find are particularly nasty disputes as a family lawyer to resolve is these legacy cottages, right? It's been in that family for 100 years. And then husband takes his wife and they use it a couple summers a month, or a couple weeks every summer. That could trigger matrimonial home designation, right, Megan?
Yeah.
Well, I think we talked about some of the cases, and that's definitely a factor.
Yeah.
Right. It brings that into play. And something I know I'll probably be harping about through this next hour is control. And when we're talking about, if I'm representing a parent who's saying, hey, I want to add my son and daughter-in-law in title, we're best friends, we love hanging out together. I'm questioning what Russell's, bringing up, which is, are you prepared for, if the relationship changes, that now your family cottage is subject to being part of a divorce proceeding, even though just by the act of bringing them alone, you don't even have to put them on title, you're really putting yourself at that risk. So that's where I think we're going to talk about some agreements that might be able to protect our clients in that area.
So Susanna, acquisition and classification. Talk a little bit about gifts and inheritances and how that, could there be exclusions, or what kind of tracing do we want to look at? What are your thoughts on that when we're talking about cottages?
So in family law, inheritances are particularly important to the equalization calculation. And it is important that when a parent is doing a will, their will is clearly set out. There are too many examples of children who end up fighting and spending long years in court fighting over their parents' assets. If a cottage was left to a child in a will, one of the first things we would like to see is the will, right? Who was this cottage left to? How were there any other provisions in the will with respect to that cottage? We would also like to see, for example, if money was left in a will, for example, so not a cottage, but money was left, and you use those particular funds to then maybe buy a cottage, can we trace those funds? Can we look back at bank statements and maybe credit card statements? And if we can, then we could make a case out for excluding that cottage from the equalization process. So good record keeping in terms of inheritances is also very important in family law. I haven't particularly had a case like this where a cottage has been excluded. Have you had one, Russ?
It depends on what use they make of it, right? If
Yeah.
the spouse is coming up and using it regularly, it could be considered a matrimonial home, and that's some of the case law we're going to include in our show notes. But what do you think, Megan?
In terms of the property being considered a matrimonial home, a cottage?
Well, can it be excluded if you purchase it with inherited funds?
My understanding was always that once you put it into a matrimonial home, if that cottage is designated a matrimonial home, you're kind of sunk, right? It's traceable in terms of you shouldn't commingle things. If you want to keep an inheritance separate, you should keep it in a separate account that's not going to be considered a matrimonial asset.
Yeah, I guess there'd be an argument if you never went there and if it was a rental investment.
And you kept title maybe in your name alone. That's
Right.
also going to be a factor too.
Yeah.
But if you only used it in the summer, right, you would have an argument for saying, well, this is not a matrimonial home. We have another home where we primarily live. This is where we left for work every day. This is from where our kids went to school, right?
I don't think that argument would carry the day. I think the judge would say, even if you're only there a few weeks every summer, you can
There's
have
a couple
more.
cases that's how centralized is the cottage around your family life.
Right.
Right. So even if you're
Right.
going there every other weekend during the summer, but you're bringing the kids there and it's really part of your family unit, there's a good possibility it's gonna get brought in.
Right. So let's see what our audience thinks of all this. We can't agree on what's going on with the cottages, but I guess that's why we've got lots of case law on these issues. Here's a question that is an interesting one. Can a cottage be a principal residence? Yes, no, it depends who's asking, right? If it's a disgruntled spouse, they're certainly going to have an opinion. Maybe it's the CRA and you're going to tell them something else, or the municipality may have certain rules and regulations regarding, if it's a seasonal cottage or if the road use is seasonal and you're using it as a principal residence or something else. Put your answer in the Q&A box and we will get to those poll results momentarily. But tax implications and transfer considerations, Megan, what do you want to be mindful of here?
Yeah, I have to say, in our experience, most people walking through our door, picking up the phone and getting the question of taxes. That's one of the main driving reasons that parents are looking to add children on to the cottage and trying to mitigate probate tax. So probate tax is paid by an estate when someone passes. The rate is generally 1.5% of the value of the estate. And there's a couple exceptions to that. So if there are joint tenants on the property, that real property will be excluded. You can use trust mechanisms to reduce that as well. And another great exception that I feel like is almost a lost art, unfortunately our office still works on a lot, is the first dealings exemption. So I'll try and keep it quick, but if you had a property that used to be in the old land registry system under the Registry Act, and you held title in registry and it was converted now to land titles, you still have the right to dispose of that property as a first dealings exemption, meaning you don't need to get probate to sell that property. And in many circumstances, we've been working with estate lawyers to determine whether that status applies to a property because you can avoid probate and paying that tax. So it can be a really great tool. We've had a client who had multiple farms. They went to another estate lawyer, said, okay, just go apply for probate. They had us look at the title and we said, wow, these 5 farms are all used to be in registry under the first dealings exemption. You don't need to apply for probate, and that saves your client $100,000 when you're talking about big property like that. So I think when you're estate planning, working with clients, whether you're transfer property or even sell a property as a real estate agent, this is something you want to understand because it's going to affect how you can transfer the property and what timelines you're held by, whether you need to go to the court and get probate or not. So that's a huge factor. Another tax that we generally run into is land transfer tax. which does apply whether you transfer or acquire land beneficially. So you may still be working with a trust, but if there's some beneficial ownership transferring, land transfer tax may apply. Of course, if there's no consideration exchanging hands, no value, then you don't get caught by land transfer tax. Another thing to think about, though, especially when adding children to cottages, this is quite common, or when you purchase a cottage and the child is coming on title with you, is that child's losing their first-time home buyer's exemption. So some children don't know about that at the time, so it's always good to speak to them about that, because they might want to buy a house down the line and now they've used up that exemption. Last but definitely not least, but for some reason is the last thing that comes to my clients' minds is capital gains. And when we're transferring cottages, which, you know, many times may not be the principal residence and may not be exempt from capital gains, we want to make sure that the client's getting directed to a tax professional and understanding what's going to be incurred when they do that transfer. And conversely, for the child that's going on, if it's going to be a secondary residence for them as well, not their principal residence, are they prepared to start incurring a property that will accumulate capital gains to be payable in future? So that's kind of my song and dance on the various taxes we run into.
Very insightful. Now I know I'm going to have you on speed dial every time I have a client with the cottage.
Yes.
I never would think of thinking of it as part of the former registry system. That's a great.
Yeah, it's a really great tool and something to look into for sure.
Yeah, great tool.
Megan, if it's called a first exemption, right? Is
Yes.
it only the first time they deal with that transfer?
Yes, exactly. You're right,
Mm.
Susanna. So that is the one thing why you want to get a real estate lawyer involved and get that advice is we need to check the parcel register to make sure there has been no interfering transfers. So if they still hold title in the original name and registry, they haven't done a transfer to add anybody on, it's going to still be applicable. I have many lawyers calling me, there was a bylaw registered. They did a survivorship. Does that count? And in both those instances, no, you still have your first dealings exemptions because you haven't actually transferred the property from that deceased owner.
Right.
So lots of interesting things with first dealings.
All right, let's see our poll results.
Oh, everyone likes the first dealings question. Look at all that.
Megan, your phone's going to start ringing.
I know.
Can a cottage be a principal residence? Yes, 58%. No, only 2%. Again, it depends. There's the lawyer contingency, 34%. And who is asking? 6%. So interesting results coming in. Megan will be answering some questions as you send them in, possibly, but let's move.
Can I start a little bit? Is that all right?
Yeah,
I see
get at it.
Susanna's
Yeah.
comment. Yes, Susanna, good comment. I'm assuming you're probably in estates. That is definitely something I believe estate lawyers, it's not my primary area of practice, but using a secondary will to exclude those first dealing assets is always great. And the second question was, if an estate requires for other reasons, will you need to include that asset? Yes. So that's why the estate planning, identify it now, figure out what properties you're dealing with, get a good estate plan in your process. And because you might have a first dealings, but you might have a bank account that needs probate and you have to now include that property. First dealing exemption for estate.
All right, I'm going to call on you to get a next question on the next poll, but let's
Okay,
go to
no problem.
valuation, complexities, and market considerations. Paul, what do we need to know here?
Thanks, Russ. Well, there's many different variables when it comes to cottages. Every cottage is totally unique. It's not like a subdivision evaluation, subdivision home evaluation, where you get 5 cookie cutters in a row. They all sell, they all sell for approximately the same price. You know what the 6 ones approximately were. So because cottages are very unique, there are so many variables that come into play when you're trying to put a value on the cottage. Without getting into specifics with each individual characteristic, when you're looking at like, for example, market fluctuations, when COVID hit, cottage value went through the roof because everyone was stopping traveling. Everyone said, well, we can't travel to vacation. Let's buy a vacation property. So cottages just went ridiculous. And then when COVID got relaxed, and everyone started to travel again, and then the interest rate went up, and a lot of people were buying cottages, on their line of credit. Their interest rate on their line of credit doubled or tripled, and they didn't also realize how much work cottages are, and then the cottage market just plummeted.
Or on that note, Paul, after their first winter in Muskoka or Haliburton, they realize there's a lot of snow up here. And my tap's not working and nobody's going to come fix it for 6 weeks, right? It's like,
yeah, absolutely. And if a lot of these properties that were purchased weren't winterized, and then people used it for 8 months of the summer, and all of a sudden now it's shut down, and they're not going to be using it for another 8 months. So,
but even the lifestyle change, right? You're used to all these services and restaurants. Most of those businesses close in the wintertime, except for a handful of them. So I think for a lot of families, it was a lifestyle shock, especially the ones who decided to move up north, and they realized it wasn't for them.
Yeah, absolutely. And as you say, amenities, right? Everyone's, we're all the amenities, and everything is right now, and everything shuts down up north, except for certain locations where it is a winter wonderland. So they're okay, but a lot of the small towns.
Right.
But when it comes to evaluating a cottage, there's so many different variables. The location, like where are you located? Are you on a lake? Are you on a river? Right? Because a lot of people don't realize that when a lot of people think of cottage, they think of waterfront. Well, not everyone buys a cottage which is on water as well. Right? It's like a cabin in the woods, right? So you have to look at that as well. So do you have waterfront? Are you road access, or are you boat access? These can obviously contribute to value as well. Are you on a small lake? Are you on a big lake? Are you on a chain lake? Generally, chain lakes are more valuable because there's better boating. You can boat for 3 or 4 hours before you see the same property again. If you are on a smaller lake, can you use motorboats? Right? A lot of the small lakes, motorboats are prohibited. So it's just canoes. So a lot of naturists, a lot of people that really like the environment, they look for the smaller lakes where you can't use motorboats. But the general population, people want boats, people want to be tubing and wakeboarding and surfing and stuff like that. So once again, generally, if you can't use a motorboat on a lake, it's going to be less value. The susceptibility to acid rain, that's something which is a very good thing to check with Ministry of Environment and Oceans and Fisheries to see how the lake is affected by acid rain. They have characteristics, they have grading. And obviously, the better grading, the more value there. Is the property winterized or not? A lot of people, are trying to get year-round use for cottages. So having it winterized is obviously important, and once again adds value. Topography. A lot of people prefer properties that are flat and more usable land for playing games or just enjoying it. Some people prefer, having a cottage high on a hill, so your views are nicer, right? They may have 300 stairs to go down to the dock, but when they're in the cottage, they have a beautiful view and they have privacy. Where you're located on a lake, what exposure do you have? Can you enjoy the sunsets, or do you want the morning sun? All of these are adding value or decreasing value. And the thing what's very unique about cottages is you can have 2 cottages very similar side by side, and the waterfront on one property is incredible, and the waterfront right next door is terrible. So that's why putting a value on a cottage, it is extremely unique. And I've never seen two cottages the same. So, it is, very different to do that. And the last thing you have to look at is the market conditions. So if you are looking to sell, is it a buyer's market? It is a seller's market. What's the inventory like? Is there an absolute abundance of listings? Or is there just no listings available to choose from? That's inventory is probably one of the biggest thing that affects value and the market. And the last thing is the time of year. When are you looking to sell, right? Are you looking to sell in the spring, technically, which is the best time to sell? Or is it in the middle of winter when something happens and you got to make a decision in terms of selling?
I think local bylaws will play into it as well, right? Can you rent this cottage? I know a lot of people were doing Airbnbs, and municipalities are cracking down on that now. And
Yes,
not
they are.
permitting. So there could be rental income or not rental income. I had a client, they had a cottage in the Kawarthas on an island. So we had to send the appraiser out on a jet ski to go. He loved it, right? This is what he lived on that lake anyway. And go walk around and take pictures. And then there's, they needed a dock to park their boat to bring everything over to the island. And there was an expense associated with that. Really kind of an interesting case. But emotional and financial family dynamics, certainly a lot of family history tied into these cottages, a lot of memories of summers spent at the cottage. Susanna, what do you think of this dynamic when it comes to cottages?
It's one of the most difficult things in family law from an emotional perspective outside of dealing with children. I have one right now where my client's parents built the cottage, but not only that, their ashes are buried there. And the husband is living in the cottage with the two boys, and she's trying to decide, what can I do? How are we going to equalize all of this? How are we going to figure out property division? And ultimately, she does want it to pass to her boys, but will that happen down the road? Who knows, right? Her spouse, may remarry, may bring another woman into the property. And it's a very emotional decision for her because of all the family connections there. People have lots and lots of memories with children at cottages, right? So it's a very difficult issue in family law when it comes to how do you separate property moving forward. And in my experience, I found a collaborative process to be quite helpful in these types of situations, because more often than not, we have the legal decision that needs to be made, but we have these clients who, for whatever reason, their own filters are cloudy because of all of these other emotional ties, and we have difficulty in speaking to them because they're not really hearing us. There's this block that they put up there. And so in my experience, bringing in the family professional who can talk with them and get into some of those weeds is often helpful in helping the clients to set aside the emotional process from the legal process. And I always recommend a collaborative process when I have an opportunity to, and when I think a family is going to be a really good fit for that type of process, especially in my case where this property is really significant to my client. Has that been your experience, Russ, in the collaborative process?
Yeah, why don't we talk a little bit, just 30 seconds or less, about the collaborative process? We talk about this every time, but there could be audience members who are wondering what's this collaborative thing? So give us the 411 on how collaborative is different than adversarial, Susanna.
So, not every lawyer is collaboratively trained, right? In each region, you can search for example, in Durham, we have the Durham Collaborative Group. A collaborative lawyer is a lawyer who undergoes specific training with respect to dispute resolution outside of the litigation process, which involves a lot of mudslinging, a lot of expenses, and you don't necessarily get to a resolution in the same way or as quickly. in the collaborative process, we tend to bring in a financial professional, and we tend to bring in somebody who is, for example, a social worker who can work with clients to figure out a parenting plan, who can figure out how do we move forward when there's something preventing the parties from moving forward, and it's hindering the legal decisions that need to be made. So the financial professional can work with you to gather up all of your financial disclosure, put together a financial statement, a net family property statement for the lawyers to look at. Of course, nothing is done without you meeting with your lawyer and without you getting legal advice from your lawyer. But it speeds up the process. It is often less costly for the clients because they split the cost of the financial professional and they split the cost of the parenting professional. We have meetings where we come together to discuss issues, what the next steps are going to be, what your homework is going to be, what decisions need to be made. And we make it, we make these decisions together in a very amicable atmosphere, as opposed to the litigation, me against you sort of atmosphere you get in a family courtroom.
I wasn't going to promote collaborative, but you brought it up. So this is you. I got this from Brian Gilbert. So this is you going through a divorce, right? And this is, you know, what your family knows about you. And this is what your spouse knows about you, right? And this is what you tell your lawyer. This was your lawyer was actually listening to. And this is what they put into the court documents. And this is what the judge might read. I can't fold this anymore. If I fold it again, this little piece of paper, what the judge decides your case on based on 2 years of litigation. But if you do it collaboratively, I feel like a little magician here. They get to look at your whole person and come up with a result that suits your family. And we can be pretty creative about it. And we can come up with options that judges cannot come up with.
Right. Yeah.
Daphne's going to throw a link into the chat about collaborative process if you want to learn more. And we have training coming up on collaborative process. I wasn't going to bring it up, but Susanna mentioned it. Paul, emotional dynamics. You're on the front lines, right? You're sitting on the couch in the living room with these two people who can't stand each other. Somebody probably cheated on one or the other one, or there's some form of abuse. And now you got to help them with their cottage sale. What are you seeing?
Well, actually, the biggest complexity that I've actually I faced is the parents that have a cottage and they're looking, they're getting old. They need to make a decision, whether it's been in the family for generations or it's been in there for 20 years. The two biggest issues that I've faced is one where the parents want to set up a will to leave the cottage to their children, but specifically eliminating the children's spouses. That's an interesting conversation sitting on the couch, especially when the spouses are there. So that's a little creative. And the other dynamic is when the parents want to keep it in the family, and one child wants to keep it and the other child doesn't want to keep it, and then you start getting discussions/arguments on how to settle that difference. So those are the two biggest problems that I've seen and I've experienced. So it's stepping very, very carefully and trying to make recommendations. And obviously, lawyers are obviously involved in how to make everything legal, but the emotional side of things is very complex.
Yeah, agreed. Little Johnny grew up there, and now he's divorcing his spouse, and all those memories are going to be gone. Let's go to our audience. see what our audience is thinking. Thank you, everybody, for sending your questions in. They're fantastic. Keep sending them in. Can a spouse use the Partition Act to force the sale of a cottage? I've got a couple options here. We'll talk about the answers in a moment. Quick stories on your point, Paul. Well, actually, I'll save my story for when we come back to these poll results. Let's go into ownership and future use. So, Megan, you want to take the lead here, and then it'll be story time.
Yeah, I feel like
Bit
Paul
of a
gave,
teaser there.
yeah, I feel like Paul's stories kind of opened this conversation in a way. And of course, on our end, being real estate lawyers, it's something we experience as well. It really depends who you're sitting with in the situation. Are you sitting with mom and dad? Are you sitting with a child who's been taking care of the cottage for the past 10 years and, you know, feels that they have an entitlement? So I think what's always been our rule of thumb is identifying that first. So who am I helping, and whether I'm in a conflict of interest or not, because a lot of the time the interests of the parties aren't the same. Mom and dad's interests aren't the same as kids. That's just the way it is. But hopefully we can find a way to bring that together. So my default when I'm dealing with parents is always retain sole ownership. You don't know what's going to happen in your life. You don't know if you'll need that asset. I know it's one thing I think continuing legal education and lawyers in the community are always saying is don't make a decision about the future that's going to have an impact on your current, right? Adding your kids now, you think you're going to have control of how you want to deal with your asset, but you don't. At that point, when you add someone on, you need their consent to deal with it. And you're also exposing yourself to the liabilities in family law or creditors. So there are a lot of risks once you lose that control. So we have to be really clear with clients on that they understand those risks before they go ahead and add someone to title. And that's the biggest thing is transferring someone onto title is immediate and irrevocable. You can't change your mind 5 years later when things haven't been going well and the kids aren't helping paying the bills and
the kids aren't talking to you anymore.
Exactly. So
Yeah.
it's a big decision to make, and we have to put a lot of thought into it. And in some ways, I say it's more complicated than your sale and purchase transaction, where we have a contract that's outlining the rules of the game. Transfers are, there's a lot of things to consider and think about. And I know we spoke about the various options, but I think a tool we spoke about too, Russell, is okay, is the parent ready to relinquish control? Maybe a life interest is a good idea.
Yeah.
And that way they can still have the right to use the property during their lifetime, if that is their goal. So I think if we get past that initial hurdle of, okay, they're ready to relinquish control and they understand those consequences, then we have a plethora of options to work with, whether it's adding the kids on as joint tenants, so they still have some input, a life interest, getting into trust, which I know is a hot topic and has a lot of tax benefits as well as liability benefits that I know Suzanne already touched on. We can maybe avoid some of the designations of the matrimonial home, possibly, or creditors. But something I'm talking to clients about too is it is a lot of work to get there. So you have to be prepared to do the right estate plan, get the tax lawyer involved in order to make it work. It's not something you should do willy-nilly.
When I see family lawyers, pursuing an equalization claim for their clients, and then all of a sudden a family trust jumps up, their eyes gloss over, deer in the headlights. What am I going to do with this asset?
Yeah, exactly.
Whole new level of complication. Paul, what's your take on ownership and future use?
Well, I would say that the most common situation that I deal with is when the parents have a cottage and they're getting to a point where they're not using it anymore, and so they're either, do we sell it now or do we pass it on to the kids? And my advice to all of my clients, especially the children, is you have to have a very, very honest and blunt conversation with your parents. You've got to tell them, I don't want the cottage. or you got to tell them you do want the cottage. When the emotions are there, you know, the parents, you know, may have had it in the family for generations, and they really, really want the kids to keep it, and the kids don't want it. They have to be honest, right? Yes, it could hurt the feelings of the parents, but you know, I think being honest with your parents and just saying, look, we don't want it. You know, we really want you to sell it now while you're still alive. You know, we want you to disperse this. And the other alternative is when you get, you know, one child wants it, one child doesn't, and the equalization or the balance of inheritance is also a very complex procedure. So, you know, one child wants it, one child doesn't, and you know, how does the one get the buyout? Can the child who wants the cottage, can they afford to buy out and pay cash to the sibling? And if they can't, and they really want to keep the cottage, then it's up to the parents now. So can the parents divide, you know, evaluate the cottage? If the cottage is worth $500,000, you know, the one child gets the $500,000 cottage, and the other child gets $500,000 in cash. Question is, do they get the cash now? Are the parents well, you know, financially, can they give the 500 now, or do they have to will it? Okay, so you know, when they pass, then they get the 500,000 because the child gets, you know, the cottage. The dynamics of that I've experienced is if they can't get the money now and it's going to be willed, then the one child says, well, that's not fair because you're using the cottage now and I can't use it. And so, you know, the arguments start, and it's funny, every time I've had in a situation, and I've had a lot over 36 years, for some reason money seems to be the biggest factor. And it's a shame when you get, you know, spouses or siblings or parents or children, you know, arguing over money, but it's a very, very common occurrence.
Isn't the easy solution just give it to your favorite kid, right?
Or your favorite realtor.
Little
your
Johnny
favorite.
has been a great kid. He's going to get the cottage. But you know, a lot of children don't appreciate the costs associated necessarily. If you look at some of these cottages, the property tax could be 20 grand a year, maintenance, insurance, upkeep, a lot of wear and tear. But let's go to our poll results. We didn't forget about our audience. Partition and Sale Act. What is the Partition Act? 10%. What's a cottage? Yes, they can force the sale. 53%. No, it depends. I don't think there's any defense to a request to sell the cottage pursuant to the Partition and Sale Act, but I could be wrong. There's some maybe limited exceptions where they might wait if there's a child needing to complete a school year or something. But
I think some of the exceptions too might be depending on the property. They can actually order splitting the property.
right.
Right. So if
Yeah.
the property is conducive to that, you might end up being the neighbor of the person you're disputing with.
It's a
But
powerful act that lots of people don't think of it, but
yes.
you bring the issue right up, and it's done on an application. You bring it to court fairly
Yeah, but
quick.
you're right to say there's not many instances where the courts are going to deny forcing the sale.
Yeah. So that's why you want to go to Susanna and talk about collaborative practice and get creative, or we're going to go back to my folded up paper there. But all right, the story time kind of ties into this. I have a colleague in one of the more famous lakes in Southern Ontario, one of the expensive ones where you can't get a lot. And he's concerned about his neighbor, but the neighbor wants to keep the cottage for the grandkids, right? And enjoy the cottage, but he wants the cottage. And so he said, I'm going to buy the cottage now and pay you now. You stay there until you die, and then when you die, the cottage is going to come to me. This is an older owners. But the benefit to the neighbor is he gets that $8 or $10 million now, and he can spend it on his grandkids and enjoy it. And he's still using the cottage. It's not going to stay in the family. And the benefit to my colleague is he knows who's going to own the property next to him, and he can use it for his own family. So this is one example of many that you can get creative in terms of how to deal with cottages and some of these disputes. But let's talk about liabilities and risks. Megan, what do we want to put on our radar here when we're looking at cottages?
I think we've been kind of touching on them as we go. Suzanne, I know we briefly spoke about, okay, when you decide to add child to title or start having child bringing their spouse to the property, you are putting yourself at risk that it could be designated a matrimonial home or fall into a divorce proceeding.
Right.
Another issue, and this more falls into when you're adding children to title, is think about what they do for a living. Are they exposed to more risk? Or do you not maybe don't want the risk that they don't pay the tax man and the cottage is going to have a lien put on it?
Right.
So those are the liabilities that you're exposing yourself to. Of course, we have ways we can address that. You can say, okay, well, I'll add you to title, but we need to get you paying for extra liability insurance. Or we enter into some sort of agreement where we have the parents indemnified for the liability that the child is exposing parents to. But again, those are contracts that have to be enforced, and we're family, and that sometimes doesn't happen. So
if there's a tax lien, are they really going to indemnify at that
probably
point?
not, right?
Yeah.
Exactly. So I'm saying those are the ways around it, but they're not great solutions. The best protection for the current owner is to not put that person on title if those are risks we're concerned about.
Any takes on that, Susanna?
I like your comment about thinking about what they do for a living, right?
Yes.
Because I know lawyers, for example, we don't want our name on property.
Exactly.
They'll go after the property.
Yeah.
So
You only have $3 million of insurance. It doesn't cover anything anymore, right?
Exactly.
Your kid's a lawyer, stay far.
Yeah. Okay. Managing ongoing costs and responsibilities. So I guess Susanna, you and I can share this one a little bit. You want to go first?
Sorry, Russ. So I think, again, we already touched on this a little bit, right? I think it's important, especially with family. Some people don't like conflict. They're non-confrontational. If the kid isn't paying, they say, oh, I'm just going to pay for it. Or, you risk getting a bad credit rating. Or if we talked about somebody putting a lien on the cottage, which will impact your ability to sell the cottage. So in all of these situations, it's really important, in my opinion, to have, when you're adding people to title, have defined roles set out. Who is going to do what? Who is going to be responsible for what? So there's no conflict later on down the road. And of course, if there is conflict, you can always use the collaborative process. You can always use mediation. We love the collaborative process here.
If you're going through a separation, I think about occupation rent, right? If you're not, this is a matrimonial home and you're not enjoying use of it, I would make a claim for occupation rent against the other spouse who's enjoying that cottage until that property issue is resolved. And that could be significant. Some of these cottages rent for big money. So nice juicy claim you want to think about. Pretty straightforward. Get comparable listings in terms of what that cottage would rent for in that neighborhood. And if it takes 2 years to resolve the litigation at 10 grand a month, this $250,000 in occupation rent adds up quick. Also, when families are separating, usually we like to maintain the status quo financially in terms of how those bills are going to be paid until there's a court order and agreement to do otherwise. Make sure the insurance is in place. Oftentimes, one spouse will pick up all the costs associated with the cottage. So we usually will do an annotation at the end of the net family property statement with adjustments, post-separation adjustments. So spouse A, paid $50,000 towards upkeep of the costs, and they're both sharing the equity in it, so that he or she should get credit for those post-separation adjustments. Standard ones are property tax, insurance, any capital payments to any outstanding mortgages, things of this nature. Required upkeep, I think, would be standard. One of the cases I was involved in with that island cottage, the costs and expenses of maintaining the dockage at the marina so they can keep the boat to access the cottage was an accepted expense as well, because you can't get to the cottage without that kind of facility. So keep those in the back of your mind. Let's go back to our audience and find out how our audience is doing. Thank you again, everybody, for playing full out today and participating with your questions. What process is the best way to resolve disputes about cottages? Well, you've heard Susanna and I talk about out of court settlements. A good part of our audience is lawyers, so I'm sure most of this will be familiar to you. So let's see what our audience thinks. We'll give everybody a moment to process that poll question. But legacy and estate planning, Megan, you want to go first? What do we want to be mindful of here? I know we've covered some of these issues off already, but
yeah, we had some audience participation too, noting how useful the primary and secondary multiple wills could be to take advantage of things such as the first dealings exemption. So I think first step is, as Paul's noted too, ask questions, talk to your family, who's interested in the cottage, really start thinking about that plan now. Don't leave it too late. And go get your title checked now, see what you're dealing with. Go speak with an estate planner and have that conversation with the family and say, who's actually interested to be part of this discussion. And there's a possibility that you have that discussion and the family doesn't work. Then we want to talk about, okay, when do we need to look at selling? And some things to think about too. I know taxes were something I mentioned. And so I think a question came through too about how taxes are paid. And yes, it's on the estate to pay capital gains. So if we are going to have only one child or some children excluded from the inheritance of the cottage, that needs to be factored into, the people who aren't benefiting from the cottage shouldn't be paying for that tax. So in that way, we look at insurance options too. We have lots of people who part of their estate plan is getting a policy to cover some of that capital gain. So that the estate doesn't have to, or saying to the family members who do want to inherit the cottage, you have to pay that. So that's definitely something to think about. And I appreciated Paul talking about how, the questions that come out about valuing that. If it's happened, the transfer is happening during the lifetime, are we valuing it at the date that it was transferred? Or are we valuing it at the date of the parent's death? And those are discussions, again, that you have to have when making your estate plan and deciding which way you want to go on that.
it's kind of a dark conversation, right?
I know. It's unfortunately we get dragged into that, don't we?
When are they going to die? Yeah.
What do you want to do with my tax?
Right. Yeah. It's very.
See, Russ, one of the I'm just looking at the Q&A. There was one question there about. I assume they're talking about siblings, one receiving the cottage and the other receiving the equalization payment in the will, and what happens if the cottage dramatically increases in value, but the payment that was agreed upon at the time doesn't. And that's happened to me once, clients, and there was a big riff and a big battle between the parents and between the child that wasn't receiving the cottage, was receiving the funds.
That's going to be a fact-driven analysis. The family law act's not very good at prospective events. They like to get a clean break and focus on date of separation and date of marriage. Date of death doesn't really play into it. But it's going to be I think the facts will certainly gear what the outcome is. If you're entering into an agreement like that, put into the agreement exactly what your assumptions are and what you think should happen if one of these events occur. So everybody, whoever reviews that agreement 5 or 10 years down later, whether it's a lawyer or a judge, clearly understands what the parties intended. What's your take, Susanna?
For me, back when I used to do wills, one of the most important clause was that exclusion, right? So if it's an inheritance and you want to make sure the new spouse or the existing spouse doesn't benefit, or that it doesn't fall into your net family property should you separate, you need to make sure that there's that clause in your will that protects that cottage.
Megan, any thoughts?
Yeah, when you said intentions, I know you were referring more to family locked, but I had a note to talk about resulting trusts. I don't know if anyone out there knows the Pecor and Pecor case, but that is something that we're told as real estate lawyers, if you're going to be transferring property, like, again, this is what I'm going to be harping on, is get clear on the intentions. Sit down, spend time with your client, understand, are we gifting the beneficial interest in this property? If so, we want an acknowledgement for that. We want to report that. We want to make it clear. If not, if you have to get drawn into court, you have to rebut the presumption of a resulting trust that the transfer of adding that child to title, they were just holding it in trust for the estate. So we want to get clear with our clients on what do we really intend from this property? Are we advancing the beneficial interest and we're done? You know, this is out of your estate. This is now your child's property. Or are we just doing an estate planning tool to mitigate tax? We have to get clear on that.
Yeah, great tip. Let's go back to our poll. We haven't forgot about our audience. All right. Mediation, 21%. Collaborative practice. Look at that, Susanna. You got 53% coming in, seeking advice of a financial professional, always advisable, whether or not it's collaborative. Oftentimes we bring tax professionals into the collaborative process when we're doing legacy planning. My view is, especially in the context of a separation, you want to make your separation agreement clear. You know, if there's going to be joint ownership of this cottage post-separation, if there's going to be a life interest, you want to make sure that there's some legacy planning. So if, for example, a separated spouse repartners, you're going to want to have that person enter into a domestic contract to preserve and protect the rights that were negotiated in that separation agreement. If one of them dies, there needs to be language in terms of whether it's going to be transferred or if it's going to be a sale is necessary and how that's going to play out. So try to anticipate a lot of these issues at a time. Bring in tax specialists, real estate specialists like Megan and Paul in terms of getting advice in terms of finding out these blind spots and building all these assumptions and future events into your final separation agreement. That's a lot to cover. Wow. Final takeaways, and then we're going to bring this train into the station. Again, I want to thank the audience online and on YouTube for these great questions. We've had some come in through the Zoom and through email. So thank you everybody for participating. You'll be getting show notes and a survey. Want to ensure that you give us your feedback so we can understand how we can improve this series and what you'd like to talk about in the future. So final thoughts in no particular order. You want to go first, Paul?
Sure. Realistically, the best advice is, just have an honest discussion with the family members to sort out any type of plans for cottage use in the future, whether you want it, whether you don't, whether you want to leave it for your children or eliminate spouses, or you just have to have that honest conversation and plan accordingly with collaborative lawyers.
Susanna?
Thanks, Paul. I think for me, the biggest takeaway is understanding that these are ongoing conversations, right? Our clients don't come to us knowing everything. And so we may have to meet with them on more than one occasion. And especially with that list of homework, okay, here's a list of things you need to think about. Go talk to your family members, come back to us. And it may take 3 or 4 sessions with us before all of this is figured out, before we have a clear path ahead. So we need to set up that expectation too, that they understand this is not a quick and easy process and there's a lot to consider.
Thank you, Susanna. Megan?
are we gonna get to any of the Q&A questions? I think I can answer one really quickly, or
Yeah, well, you answer the one you want. And
okay.
then,
Partition and Sale Act. Everyone's saying you have to be an owner. It says any person interested in the land. So it doesn't say the person listed on the parcel register. Just so I know, it's a very interesting act and something to think about. But I definitely think, Russell, as you've already pointed out, that could bring in spouse, that could bring in common law spouse, that definitely could bring in the beneficiaries if there's a trust arrangement.
could be
So
a
something to think
constructive
about.
trust, resulting trust, joint
Exactly.
venture. We'll come up with the trust and we'll get you involved in it.
In terms of my words of sign off, I definitely agree with Paul and Susanna. Take time with these decisions, have a plan, and look at your title early, think about it early, and it is an emotional time, so don't rush it. These decisions are never good to rush. Don't want to say I need to transfer it tomorrow. Take a couple months to think about it and setting up your plan.
Yeah,
Sorry,
these
Megan,
are-
just to add to that, that's section 2, right?
Yes.
Any person who has an interest.
I think three, sorry, who may bring an action or an application.
It's in there somewhere.
It's in there somewhere. It's a pretty small act. You can't get lost.
Yeah,
2 and 3, yeah.
this is a big asset for a lot of families. Next to the home and maybe a pension,
Yes.
this might be the next one in line. Super emotionally charged asset. Lots of people don't think clearly or dispassionately when it comes to cottages. So many memories and good and bad tied to these assets. Oftentimes they end up in 2 years of litigation and hundreds of thousands of dollars spent on legal fees, in addition to the stress of going through litigation and the strain it puts on family dynamics, especially legacy cottages. These families don't talk to each other anymore. Quite simple as that. Grandparents don't see grandkids anymore. That's how nasty these disputes get. And there's tax pitfalls too, right? If you get this wrong, CRA is going to come after you for whatever they can. So think of that. So my advice is spend the money ahead of time. Talk to the Pauls of the world, get good real estate advice. Talk to the family lawyer, real estate lawyer, financial professionals, tax professionals. You have to spend a few $1,000s up front. It's going to save a lot of headache down the road if you get it right. So that's my takeaway for today. Megan, Paul, Susanna, I want to thank you for spending your lunch hour with us. And look who's back. Daphne's back.
Just like that.
Thank the audience, of course. Thank the audience, of course. Welcome back, Daphne.
Thank you. Yes, thank you so much to our panel today for donating your time and sharing your knowledge with our audience. It is much appreciated. Just a reminder for the lawyers in the audience that this session has been accredited for 1 hour of professionalism content with the Law Society of Ontario. And to all of our audience members, all the resources mentioned today will be included in the show notes and YouTube description. So you can find the all the sections and the acts mentioned today. And yeah, thank you again for joining. To our audience, thank you for participating in the polls and the Q&A. And that's it. Thank you so much for tuning in to Family Law Now.
Have a great afternoon, everybody.
Very much.